Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Guess I should hit the stage, huh? Hello, everyone. It is Pam Esquire, also known as your law intellect. I know I'm a little bit early, but I moved it from, it was actually at 7 o'clock. But then when I saw phone calls from prison was going live, I didn't want you guys to have to make that hard choice on whether you're going to watch the reality comedy show over there or if you were going to come over here. So I moved it to 7:30. I figured you guys would appreciate that. And so that's what we did. Those calls are a trip. We will get back into Nesto on Friday because that is when he has his bond hearing on the one charge. Well, one case. It's like four charges, of which he does not have any bond, BAWN, on. So if you guys could do me a favor as you come in, hit that like button. Subscribe if you haven't done so already. And yeah, thank you so much. There's phone calls from prison. Thank you for gifting 5 memberships. I appreciate that. Whoever gets the membership, make sure you guys thank phone calls from prison. Thank you. Thank you. Yeah. So we are here. You guys seen the title. Back in November, it was a week before Thanksgiving. There was this avalanche of lawsuits that occurred over in New York. And the reason why it happened is because there was a law that was passed which allowed people that were accusing individuals of SAing them. It could have been in the 70s, it could have been in the 80s, it could have been in the 90s, it could have been in the 2000s. Whenever it was, you had 1 year to look back and say, I remember when so and so did this to me. I'm going to sue. Now, what a lot of people don't know is there were several lawsuits that were filed during that 1 year. A lot of those were people that had SA that were alleging that they were SA'd in the prisons, like the women prisons there. Those was actually the majority of the lawsuits. But our eyes got open to this when it started being some of yours and mine faves that ended up being accused. And it started with Diddy. Well, actually, I think it was L.A. Reid, maybe right before that. I think that was one of the first ones in the music industry that I saw. But Diddy's was the explosive one because it had to do with his relationship with Cassie, which we know that he had. And she was very descriptive. She named dates, times, people, hotels, locations, very, very specific. It read like a novel. And what happened was within 24 hours, Diddy said, F this. What do you want? Here go this envelope. I'm going to need you to go away. Well, I don't know if Diddy thought that was going to be the end of it, but I knew how these things work. You're going to get some people that are going to get the courage because they say that this happened to them. And you're also probably going to get some people that's making it up because they feel like it's a money grab, that they can get a couple of dollars from it. So we started going over sometimes twice a day. It was lawsuits. It was one with Jamie Foxx. It was one with Harv Pierre, which is the president was the president of Bad Boy Entertainment. We were just back to back, and I didn't even go over all of them because there was some other Levine, I think. There were so many of them, we couldn't even go over all of them, but we were definitely trying to keep up with the Diddy stuff. Thank you so much for the super sticker, Patrice. I appreciate you. That is so kind of you. Um, so we went over that and we were just, I mean, it was in the middle. I'm doing this work and then I'm like, dang, another lawsuit filed, and I'm jumping on here. Well, there was only 1 year. So it ended like in November, but there was one statute, I believe that was 2 years. It was like gender motivated, which was beyond that. So there was one lawsuit that was filed, and it was from a lady, a young lady. She said she was 17 from Detroit, and her name is Jane Doe. She didn't want to say what her name was. And so in court, they've kind of been fighting because about whether they can release her name, not release her name, and all of that. Amir, welcome. Welcome, Amir, to the family. We appreciate you. Welcome, welcome, welcome. Um, so now I had on my calendar that Diddy had to respond. And many people probably thought that Diddy was going to try to silence a lot of people. I knew strategic wise, he was going to have to fight at least one of these lawsuits because if that's the case, when is this going to end? Well, he has chosen for now to fight Jane Doe. And this is in federal court. And this case was actually against, let me look at the title. It was Jane Doe, and this had the trigger warning too. So this one was actually against Sean Combs, which is Diddy, of course, Harv Pierre. They alleged it was a third assailant. There was also Daddy's House recording where this allegedly happened. Remember, this lawsuit had pictures in Bad Boy Entertainment. Well, I'm going to start with, for those of you, so I don't have to go through this complaint because the summary of the facts goes over this complaint. Because the Daddy's House and I believe Bad Boy Entertainment Holdings, on their first response, they filed what's called a 12B motion. They are alleging that based on the pleadings alone, which means we don't have to add any exhibits. We don't have to do any of that. We don't have to go through discovery. You have not stated a claim against Bad Boys or Daddy's House. So they have filed a motion to dismiss as their first filing. So that was filed on yesterday. So let's do theirs first. They have a motion to dismiss. He has lawyered up. So he got Jonathan Davis over there in Rockefeller Plaza, New York, New York. He got law offices of Bobby C. Sternheim over there in New York, New York. Then he has added Sean Holly, who is over there in California. Many of you guys probably are familiar with Sean Holly. She was one of the ones that was she represents a lot of high profile people. She worked for the Johnny Cochran firm, if I recall, at one point back in the day. But she also represented Tory Lanez at first. That was who was supposed to represent him before Magdesian came in. And we know how that ended. He's in there right now doing time. But Sean Holly was the original lawyer that was on there. You said what? You said I had to resub. YouTube kicking me off. I don't know why it's been happening a lot lately. Oh my goodness. My son said adding Sean Holly was nice. He did his thing. He got a whole legal crew over there. I'm sorry that happened to you. I don't know what goes on with YouTube. Unfortunately, I can't control it. And sometimes if you don't get notifications as well, if you sub to me like when I first started a year and a half ago, sometimes you got to unsub and resub and then you might get the notifications. So I don't know. It's crazy because on some videos I'll get like everybody will be flooding in here almost immediately. Then it's some they're like, I didn't, I'll see on the replay, they'll say that they never got the notification. So I don't know. So this is the motion to dismiss that was filed on behalf of Daddy's House Recording and Bad Boy Entertainment Holding, and they're the corporate defendants in the lawsuit. So if you see corporate defendants, that would be all of them. So they're saying they should be let off out of this complaint off rip. That's what they're alleging. So they say the preliminary statement is plaintiff alleges a single cause of action against 5 defendants under New York City's Victims of Gender Motivated Violence Protection Law. Now, I believe that was 2 years that they had under that specific statute. The other one was a year. So VGM is referring to that Victims of Gender Motivated Violence Protection Law. All defendants categorically deny plaintiff's allegations against them, but as to the 2 corporate defendants, as a matter of law, plaintiff has failed to state a claim upon which relief can be granted against them. Plaintiff's claim fails against the corporate defendants for at least 3 reasons. First, in plaintiff's attempt to hold the corporate defendants liable, plaintiff relies on language that was added to the VGM in 2022. Such language, which expands the VGM scope of liability, is inapplicable to plaintiff's claim, which is based on misconduct that allegedly occurred in 2003. Thank you so much, Brenda Patterson. I see you. Retroactive application of amendments is presumptively disfavored, and there is no basis to find that the amendment operates retroactively. So they're saying that they're using language in a 2022 amendment, and you don't go back when it comes to the language, when it comes to the corporate individuals. That's their first argument. The second one is, even if plaintiff were permitted to rely on VGM's amended language, she nonetheless fails to state a claim upon which relief can be granted against the corporate defendants beyond alleging that they, quote, owned and, quote, operated a location where a sexual assault occurred. Plaintiff alleges no facts that the corporate defendants had any involvement whatsoever in any alleged misconduct. Such threadbare allegations as here do not and cannot form the basis of a claim against these corporate defendants. And their third argument is the alleged misconduct of the individual defendants cannot be imputed to the corporate defendants. So if you're accusing, what they're saying is, if you're accusing Diddy and you're accusing Harve Pierre, you cannot make the corporation responsible for what they've done. And they say it is well settled that sexual assault and related misbehavior are outside the scope of employment and cannot be imputed to a corporate employer. Further, as defendant Sean Combs, plaintiff has not alleged any facts or legal theories that can impute his alleged behavior to corporate entities he allegedly owns. So they go over relevant complaint allegations, and you guys have to listen how they rephrase this on what the complaint was saying, and then it should jog your memory of when we went over the complaint, because it was a while ago. We went over it a couple of months ago, but I told you once Diddy responded, we were going to go over that here because, again, these are just allegations. He has not been found liable for anything. He is not liable, and you have to prove each and every allegation or claim that you put out. So right now, it's just an allegation. So in their relevant complaint allegations, they say, thank you so much, Rain C, for the super chat. I appreciate that. She said, thank you for breaking this down, Lady Esquire. I appreciate your support. It has, in broad strokes, the complaint alleges that on an unspecified date in the year 2003, defendant Harve Pierre and another defendant identified only as the third assailant befriended plaintiff at the bar of an unnamed lounge in the greater Detroit area. You see how they put that? Like, basically saying this complaint lacks a whole lot of detail. That's what they're trying to relate to the court. After befriending plaintiff at the bar, Mr. Pierre allegedly telephoned Mr. Combs, who invited plaintiff to meet him that evening in New York. A, quote, private jet was allegedly waiting to transport her there. Plaintiff allegedly agreed to accompany Mr. Pierre and the unnamed third assailant, But before leaving the lounge, Mr. Pierre allegedly smoked crack cocaine in front of her and actually assaulted her in a bathroom. Undeterred, plaintiff willingly traveled with Mr. Pierre and the third assailant, culminating in her arrival at Daddy's house recording studio in New York City, where she allegedly was plied with copious amounts of drugs and alcohol. In her allegedly intoxicated state, plaintiff claims she was actually assaulted by three men and abandoned on the bathroom floor until the next day when she was driven to an unidentified vehicle, transported to an unidentified airport, and flown back to Michigan on an unidentified aircraft. Missing from the complaint are any substantive allegations concerning the corporate defendants relating to the alleged misconduct. The complaint identifies BBE or Bad Boy Entertainment as a music, media, and entertainment company founded and owned by defendant Sean Combs, with Mr. Pierre having been made president a decade prior to the alleged event. It further alleges that BBE owned and operated Daddy's House recording studio where the New York assaults allegedly occurred. And finally, quoting language from the VGM, the complaint alleges a legal conclusion that BBE enabled defendants' commission of the crime of violence motivated by gender. No other facts are alleged about BBE. The complaint alleges less about Daddy's House. Although it mentioned Daddy's House as a location in several paragraphs, it references Daddy's House as a business entity only in paragraph 16, where it is identified as a music, media, and entertainment company, which owned and operated the Daddy's House recording studio. No other facts are alleged about Daddy's House. And what's interesting is I believe the person, this is the complaint that the person that is that represented Cassie, you know how thorough that complaint was, is the same person I guess was representing this young lady that is out of the D. So of course they go over the argument, which is the standard of review. We know what their arguments are. So the points, they're basically saying that the statute is not retroactive. So it shouldn't apply to the corporate defendants. And then they have all of their case law as to why they're saying that argument. Let's go to point 2. Their allegations fail to state claims upon which relief can be granted. So even if plaintiff were permitted to rely upon the amended language of VGM, and she is not, her claim would still fail to state a claim against the corporate defendants. Plaintiff bases the VGM claim on the following. 1, BBE and Daddy's House are alleged to have owned and operated the location where the assaults were allegedly committed, and BBE allegedly enabled the commission of the alleged sexual assaults. Plaintiff's threadbare allegations cannot sustain this purported claim. The mere fact that the corporate defendants owned and operated a location in which misconduct allegedly occurred, whether true or not, does not make them liable. And they have their case law here, which they rely on for that proposition. Nor does plaintiff's vague and boilerplate allegations equate to a plausible allegation that the corporate defendants directed, enabled, participated in, or conspired in the commission of any misdemeanor or felony against plaintiff. A complaint must provide each defendant fair notice of what the plaintiff claim is and the grounds upon which it rests. And it has the case law. Consequently, courts will dismiss claims at the pleading stage where the complaint fails to give the defendant any notice of the misconduct it is alleged to have committed. More case law. See, I'm always like, where is your authority? And let's go down. Notably, the complaint alleges no acts or omissions by the corporate defendants or their agents that describe any involvement by them in misconduct that allegedly occurred in connection with the alleged incident. Plaintiff's apparent view is that complicity is a crime of violence. should be inferred based on a single boilerplate allegation of ownership and operation. This view is untenable and is a radical departure from the well established pleading standards under Federal Rules of Civil Procedures 12. And then it has the case law. So they're basically, with all of this that I'm saying, they're saying you haven't really said anything. You just threw our name in the caption, probably because we're the ones with the pockets, the big pockets, and they probably have insurance. And so you're trying to make it seem like he was somehow directed by the corporation adopted this man's behavior, even if he did do it, but you haven't really shown none of this, and you have to show how the corporation is involved. Put simply, not a single probative or supporting allegation can be found in the complaint that would warrant including the corporate defendants in this claim. Similarly, futile is plaintiff's legal conclusion that BBE enabled defendants' commission of the crime of violence motivated by gender. It is a black letter law that copying the language of a statute and planting it in a complaint is insufficient to state a claim. And they have more case law. So just because you put what the statute says and put it in your complaint, that is not enough for you to state a claim. You have to add specific facts. This is what they are arguing. These are conclusory in nature, is what we call them. You're just making conclusions. It doesn't have anything to lead up to that conclusion. Okay. Accordingly, even under the amended language of the VGM, plaintiff fails to state a claim against the corporate defendants. So now their third point is the alleged misconduct of the individual defendants cannot be imputed to the corporate defendants. Having failed to state a claim against the corporate defendants, plaintiff also cannot sustain a claim them based on a theory of vicarious liability arising from the alleged misconduct of the individual defendants. Aside from the fact that plaintiff has not alleged vicarious liability, the complaint also fails to allege facts that give rise to such liability. So Mr. Pierre and the third assailant's alleged misconduct cannot be imputed to the corporate defendants. The complaint fails to show any linkage or tie between the third assailant on the one hand and Daddy's House or BBE on the other hand. And there's more case law. The third assailant is simply identified as Mr. Pierre's friend. There is no allegation that the third assailant was under the authority or control of the corporate defendants. Thus, there is no basis to hold the corporate defendants vicariously liable for his alleged misconduct. While Mr. Pierre is alleged to be BBE's president, as employer, BBE cannot be held vicariously liable for Mr. Pierre's purported misconduct under New York law. While an employer may be liable for the torts of its employees when an employee's actions fall within the scope of his employment, it is well settled in the Second Circuit that employers are not liable to plaintiffs for sexual assault under a theory of respondent superior, since sexual misconduct is necessarily outside the scope of employment. So they're basically saying, just you cannot blame the company because that's not within the scope of his employment. His employment does not include having this type of misconduct. So it's not like he somehow during his employment was negligent or did anything like that that would hold the company liable for his actions. So, like for instance, and it's not to minimize it, but I think it's the best simplistic way to talk about it. If you go to a grocery store and you have an employee who is in the store working and decides that he's or she is not going to pay attention while she's driving the little cart, and you're standing looking up at the shelf and you don't see them coming and they hit you, that person was in the scope of employment and therefore they may be held liable. You sue the actual company because they were in the scope of employment doing what they were supposed to do in their job, and then they hit you. Then they have some case law where it's Doe versus Al-Saud, and it basically stands for the proposition that dismissing respondent superior claim against employer and noting that no decision in New York has been cited to date in which the doctrine of respondent superior, which is basically vicarious liability As an employer, I'm responsible for the employee was held to apply to sexual assault. So they're saying there's no law that holds a corporate defendant responsible for any alleged assaults. Indeed, where an employee undertook conduct for personal reasons or had personal motivations, the employee's conduct cannot be attributed to his or her employer. And then they have a bunch of case law. Here, even if plaintiff attempted to raise a vicarious liability theory, it would be futile. So they didn't even allege vicarious liability in their complaint. But I think what these attorneys are doing is anticipating that they might try to amend their complaint in order to find a way to pull the corporate people in by saying it was vicarious liability. So we're just going to cover that anyway right now, just in case. So we can just let you know, Judge, that even if they decide they're going to amend this complaint and add vicarious liability, we got the case law to say that that ain't even going to work. So here, even if plaintiff attempted to raise the vicarious liability theory, it will be futile. Plaintiff's claim against the individual defendants is premised on sexual assault. Such alleged behavior is driven by personal motive and outside the scope of employment. Plaintiff does not allege otherwise, thus, neither corporate defendant can be held liable. Then they got Mr. Combs' alleged misconduct cannot be imputed to corporate defendants. Plaintiff pleads no facts to impute the alleged misconduct of Mr. Combs to the corporate defendants. While Mr. Combs is alleged to be the owner of both corporate defendants, there is no basis to hold them liable for his alleged actions. In exceptional cases, a corporate entity may be liable for the acts of its owner under a reverse piercing theory. However, reverse piercing is appropriate only where one, a corporation is dominated such that, for example, corporate formalities are not observed, and two, the domination was used to commit a fraud or wrong that injured the party seeking to pierce the veil. Piercing the corporate veil is a whole nother thing that you learn in corporations. Sometimes even those people separate themselves from corporations because it's so intermingled that they'll take your money from your corporation because it's really not separate and apart from you. And it's called piercing the corporate veil. And they say disregard of the corporate form is warranted only in extraordinary circumstances, and conclusory allegations of dominance and control will not suffice to defeat a motion to dismiss. Suffice it to say, not only are there no allegations concerning any non-observance of corporate formalities, there are also no allegations regarding any dominance and control over BBE or Daddy's house by anyone. No claim has been stated against the corporate defendants, and they should be dismissed from the action with prejudice. Now, if you guys remember, and that is the end, the conclusion is basically, for all the foregoing reasons, the corporate defendants respectfully request that the court grant an order dismissing the complaint against the corporate defendants with prejudice, together with such other and further relief as court deems just and proper. So that is their conclusion. So what they are doing is off rip. They're saying you have not proven that these corporate entities should even be in this complaint, and Judge, we think that you should dismiss this with prejudice. Now, with prejudice means you cannot come back. No, without prejudice means you can come back. So yeah. So Fine 9J says, however, if I was at a business trip and dinner and accidentally harmed someone, wouldn't my employer be liable? Or teachers that post inappropriate pic on Facebook off the clock but still get fired? Okay, so you're looking more so at handbooks, people contract, and they'll have morals clause. That's totally different. They can fire you if you go outside of their morals clauses, or they have certain ethics within a specific community. That's why you can't lump it together. Now, it may be that Jane Doe's attorney comes back and finds other case law that says you can you can't not pierce the corporate veil, but I guess they would try to argue that as well, to pierce the corporate veil. But they may say, no, you guys are liable for it. Like they're one and the same. Is basically what they try to say. Yes, there's a separate entity, but if you have such control that you can't tell your personal from your business, then we can take it from your business. So that's what they're basically arguing right now. And again, this is their side. So I'm sure they're going to try to find some case law. I don't care if it's from 1920 that probably refutes some of the things that was said. I did notice there was a lot of what we call non-published opinions that were in there, which isn't, isn't like let me see. Look on here and make sure I'm yeah, I was seeing a lot of non-published opinions, and usually you do published opinions. Published opinions are those that are adopted by the court as published. Non-published opinions are not authoritative. So they do have a lot of non-published opinions, so it wouldn't shock me if there are some opinions that are the opposite of this. Let's see. Christine, good to see you. Beautiful said, did Jane Doe fail to sue the individuals who actually assaulted Miss Doe? She did. She sued Harve Pierre, who she's alleging assaulted her. She also sued Diddy, and she sued an anonymous third person. So there's a John Doe. She doesn't know who that person is. And apparently, I don't know, perhaps she thinks that Harve Pierre is going to. I don't even know how you would find this third person, because let's just look at this realistically. Is Harve Pierre going to say, that was my man Tommy's from, because they were here in Detroit. So they say that was my boy Tommy from over there on Finkel on the west side. Like, I don't think he's gonna say that, because then he's gonna be admitting that this incident even happened, or that he was with her in the first place. Like, he will put himself on the scene. So how are they gonna even find who this third person is? But I think the reason why they put a third person in there is because if her story is, or her, her allegation is that there were three people, you have to try to fill that spot, because you don't want what they call an empty chair. So I can blame everything on the person that you didn't put in the complaint. I can argue that you did not join everyone that should have been in this complaint. I can point to a person that's not a part of this complaint and said it's all their fault. Maybe it's John Doe that you don't know who they are. They did everything, because you're telling a story about a John Doe, but you haven't sued a John Doe. So it's really just a placement. I will be very shocked if we can even figure out who this alleged John Doe is. Shane, what up, though? But yeah. So that's that. This was a complaint that I was kind of like, oh, okay. It was, again, it was one that we know there was a interaction. And how do we know that? Is because she did put pictures. So when I saw the pictures, I was like, oh man, okay, I see where this is going. Let me pull up this complaint. So this was one of which she said, let me go to these pics. So there's the pictures. And she's now, this is supposed to be after. So she's alleging she was at a lounge in Detroit. She met Harve Pierre. Harve Pierre was there with his homeboy. He was allegedly doing drugs. He takes her in the bathroom, and RAs are in the bathroom, SAs are in the bathroom. And she was there with her friend too. So that's what, I don't know what happened with the friend, but he called before he takes her to the bathroom. He calls Diddy on the phone to basically, I suppose, confirm that he really knows him or whatever. So there's a phone call with Diddy after he goes ahead and allegedly does these drugs, go in the bathroom. And she says she was SA. And then she says something was slipped in her drink, I guess. And so that was part of it. So they go onto a plane, and they take the plane to New York. It was a private jet. They take it to New York. They go to Diddy's house, or Daddy's house, I think is the name of it. And these are the pictures to show that she was there. So this is her sitting on his lap. This is her showing that she's there, showing the PD doing this and posing. This is another picture. So she still kept the pictures from whenever she was at his studio. So I'm gonna recap on what she said from here, because I hope I ain't leave anything important, anything out. But she says specifically in 2003, so we're talking about 20 years ago, when she was only 17 years old and in the 11th grade, Miss Doe was trafficked and gang RA'd by Mr. Combs, Mr. Pierre, and the third assailant. In short, when she was just a teenager, Miss Doe met Mr. Pierre and the third assailant in a lounge in Detroit, Michigan area. While at the lounge, Mr. Pierre insisted that he was, quote, best friends with Mr. Combs and even called Mr. Combs with Miss Doe. Mr. Combs convinced Miss Doe, who was half his age at the time, to accompany Mr. Pierre and the third assailant on a private jet to come to his studio in New York City. Before they left for the private jet, Mr. Pierre smoked crack cocaine in a bathroom at the lounge, in which he also actually assaulted Miss Doe by forcing her to give him oral. Mr. Pierre, third assailant, and another gentleman then escorted the high schooler to a private jet, which flew them to Teterboro. Probably saying that wrong. Teterboro, New Jersey. My husband will be upset with that because he's from New Jersey and I butcher their names all the time. There were SUVs awaiting the group at Teterboro, and the four of them were driven to Daddy's House Recording Studio, a studio famously owned and operated by Mr. Combs and Bad Boys. While at the studio, Mr. Combs and his associates, including Mr. Pierre, plied Miss Doe with drugs and alcohol. Okay, so she wasn't okay. It looks like she didn't get the drugs and alcohol until she was at the studio. So while she was here in Detroit, I don't, unless I missed it, it don't sound like that's what occurred in Detroit. But she got on the plane after she saying she was forced to oral. As the night wore on, the 17-year-old Miss Doe became more and more inebriated, eventually to the point that she could not possibly have consented to having sex with anyone, much less someone twice her age. While at the studio, Miss Doe was gang RA'd by Mr. Combs, the third assailant, and Mr. Pierre in that order. So she said Puffy was first, the mysterious assailant was second, and then Mr. Pierre was third. While Mr. Combs was RAing Miss Doe, he complained that he could not get off unless she pinched his nipples as hard as she could. Mr. Combs then watched on a third assailant, who Miss Doe had not even realized had begun to have sex with her, RA'd Miss Doe as she told him to stop. After the third assailant was finished, Mr. Pierre took his turn at RAing Miss Doe and then violently forced her to give him oral, during which Miss Doe was choking and struggling to breathe. When Mr. Pierre finished, he left Miss Doe in the bathroom alone. Miss Doe fell into a fetal position and lay on the floor. Her vagina was in pain. Finally, after a period of time, Miss Doe regained her bearings. However, she could barely stand up following the gang RA and had to be helped to walk out of the building and back into a car. She was taken back to an airport and flown back to Michigan. However, has very limited recollection of her transport home and only remembers being in the car sometime early in the morning. So then they go on to say, unlike many victims who have come forward after decades, Miss Doe can prove that she not only met Mr. Combs on the night in question, but was in his studio in New York City with him on that night. Remember, when viewing these, Miss Doe was 17 years old. So that's the allegation, and she has the picture for those of you that needed needed it refreshed. Well, Diddy has also responded, of course, because his answer was due as well, and he basically said it's all a lie. So when you answer a complaint, you have to answer each and every paragraph by admit, denying, or neither admitting or denying, and leaving the plaintiff to their proofs. People word it different ways, but that's really what it is. Sometimes you are without sufficient information to either admit or deny. That's the same thing. So in this, when it came to the allegations, they admit, of course, that this young lady said the reason why she filed is because Cassie filed her lawsuit and it gave her the strength to do it. So there's a lot of information about Cassie filing her lawsuit. Of course, she admits to that because heck, you can't deny it. She filed the lawsuit, and all the other people that have filed, they put this in here. So they admit to that, but they say all the rest of this colorful hyperbole and mischaracterization, they don't. And basically, he vehemently denies it because it wouldn't make sense to read it because then unless I did it side by side of the complaint, because like for instance, it says paragraph 4 of the complaint alleges characterizations and or opinions for which no response is required. And on that basis, defendant denies those allegations, except defendant admits that a pseudo-anonymous plaintiff filed a complaint in the Supreme Court of New York County in New York on November 21st. So basically, unless you read paragraph 4, you're not even going to know what they're talking about in paragraph 4. So you have to answer it line by line. So the gist of his response is he's denying it. He's denying each and every allegation. He's saying it did not happen. But what is very interesting about this complaint is you also add what's called affirmative defenses on what your defenses are. And I pretty much knew that someone was going to defend on the fact, which a lot of the intellects have brought up in the comments, is it fair that people can come 20 and 30 years later and make these type of allegations? You get people that are essayed and people will tell you it takes years, some time for them to get the courage to come forward. They just got the courage after all these years. Most people had to go through therapy and all of that. But from a legalistic standpoint, is it fair to allow someone to come 20 years later? And the reason why that question is asked is because as a person that does wrongful convictions, I deal with people that were in jail for 20 years, 30 years. When you're trying to do those type of cases, they're very, very difficult. You can really know in your heart of hearts that somebody is innocent. However, if you got to go find the gardener might not be alive. If you have to go back and you now videotapes, a lot of tapes are recorded over in these stores, banks, street cameras, all of that stuff. They record or they get rid of them. In the moment within that time, I can preserve all of that stuff. 20 years ago, I could have preserved it if I'd known that someone was going to make these allegations against me. I really am without the evidence to defend myself. When you allow someone to come from the 70s or the 80s or the 90s or 2000 in order to say, I did this, it's going to be a credibility issue. And we all know right now, Diddy's credibility is not the greatest because of all the allegations against him. So the first defense was the complaint fails to state a claim upon which relief can be granted. The second was the complaint is barred because plaintiff cannot satisfy all or some of the required elements of her claim under the Victim of Gender Motivated Violence Protection. But the third one is what kind of piqued my interest because I was wondering when someone was going to attack the constitutionality of allowing people to come forward all these years later. So in his third defense, Diddy says the complaint is barred because the VGM is unconstitutional on its face, both substantively and procedurally. Plaintiff's decision to wait more than 2 decades to file her complaint has prejudiced defendant as he has lost the ability to defend himself fully and fairly in this action. For example, some or all evidence that otherwise would have been available if the action had been promptly commenced may be unavailable, lost, or compromised. The absence of evidence materially impacts defendant's ability to defend against essential aspects of plaintiff's claims. Witness identification, availability, and recollections are likely compromised due to the substantial passage of time since the alleged incident. Allowing this action to proceed violates plaintiff's rights under the United States Constitution and the New York State Constitution. Diddy may, if necessary, if he doesn't beat these claims, he has the money to appeal this, to go all the way to this here United States Supreme Court in order to try to invalidate this statute because of the prejudice that he's saying that I can see it being prejudicial. I can see that argument, because as a person that has to go back in time to try to help my clients is very, very difficult. I have a case now where the prosecutor is deceased and the defense attorney who originally defended my client 20 years ago. So I don't even have your recollection of what happened on that day. I can't even come against the defense attorney and say you didn't do everything you were supposed to do, because I can't put him on the stand and do an evidentiary hearing to see what you did or didn't do, or what information that you may not have done to be ineffective assistance. I'm lost with some of the tools I would have had if I was able to defend a person 20 years ago. So this is what he is arguing. It would not shock me if he tried to challenge these statutes that are allowing people to go back and reach back 20 and 30 years. And many of you probably agree with them. Why? Because I seen it in the chat where people was asking. So it's not to be inconsiderate, it's not to be non-empathetic, it's not to be any of that. It's just when you get to the legalities of it all, it's going to be difficult. There's no way to like get around it, that it's going to be difficult. So I can appreciate someone that says, this happened to me. I just now got the courage. This opportunity came. I seen Cassie and I said, if she can put all her business out there, I can put my business out there. But from the legality standpoint, if we are a fair system on both sides where you're innocent until proven guilty, you're non-liable until they prove that you are liable from a civil standpoint, how is he really going to defend himself? Genuinely, it's going to be, she said this happened, against what he said. Now, she kept pictures of him from back in the day. So it would be curious, do you have a ticket? Well, she was on a private jet, so I guess she wouldn't have no type of plane ticket. Wasn't at a hotel, so you couldn't say like it was this hotel at this time. And I remember the lobby had red in it or something like that. I just don't know how he would even defend it. So I figured that was going to end up being one of the defenses. So the fourth defense is the complaint is barred under applicable statute of limitation, including without limitation, because the statute of limitation revival provision of the VGM on their face violates the due process right of defendant under the U.S. Constitution. Again, challenging the statute, saying that it's unconstitutional on its face because it violates his due process. Everybody has a right to due process to defend themselves in court, whether you like what they're being accused of. They still have the right to defend themselves. Because everybody who files lawsuit ain't being honest. Everyone that accuses you of doing something wrong doesn't mean you actually criminally did it. You have the right to have them present their case, and you have the right to defend yourself and to present your case. The fifth defense is the complaint is barred under the doctrine of laches. Laches is basically you done waited a long time. That's what laches is. Now your claim is stale. So plaintiff has waited an unreasonably long time to file this action, more than 2 decades, and thus defendant's ability to defend the claim has been prejudiced due to this unreasonable delay, including denying him access to, among other things, documents or other physical evidence and witnesses with complete or reliable memories. The sixth defense, the complaint is barred based on plaintiff's acts, omissions, or other culpable conduct. Damages, if any, must be reduced by the proportion of which such conduct is attributed to the plaintiff, notwithstanding defendant denies causing any damages to plaintiff. The seventh offense is the complaint is barred because plaintiff would be unjustly enriched by any judgment in her favor against the defendant, notwithstanding defendant denies causing any damages. Unjust enrichment means you're getting money you shouldn't even have, that you're not even entitled to. The eighth offense is the complaint is barred based on the doctrine of unclean hands, as the claim alleges an entirely fictional account that never occurred. Unclean hands mean you come up in here and you're not right. You point a finger at me, but you're not right, basically, in layman terms. Unclean hands is an equitable defense as well. Ninth defense is plaintiff's damages, if any, are governed by the collateral source of payment rule, which reduces any damages that would be awarded in her favor against defendant, notwithstanding defendant denies causing any damages to plaintiff. Temp defense plaintiff is barred from recovery of any damages because they are uncertain, contingent, and or speculative, notwithstanding defendant denies causing any damages to plaintiff. Reservation of rights. So most of their defenses talk about you don't deserve any money and you can't prove that you do. But I think the major thing in this case, again, and they demand a jury trial. So they're ready to go at it. But their main defense and their main thing that they're focused on is the constitutionality of it all, of allowing people to come all these years later to say you did something and then I can't prove it. Like, how can I really defend myself? Because this was 20 years ago. I can't, I don't even know where I was 20 years ago. How many of you know what you was doing 20 years ago? I'm like, how old am I? I don't even know how old I am sometimes. 20 years ago. So yeah. Tanika said, I hope she has more evidence. Perhaps she does. Libby said, I bet she has more evidence. Puffy has a bad reputation. How can he justify her being in the studio? This is from Phyllis Crosby, where a lot of people I know people that's been to Daddy's house. They didn't have those experiences, but he did open up studios and allow people to come in there. So that's not really a shocker that she was there. But Beautiful said, I bet the motion to dismiss will be denied. Um let me see. I see I'm gonna have to block people. I don't have no mods in here like that. Um, Kathy said if she got pics, maybe she got a lot more. We'll see. But what is he gonna have? You know what I'm saying? Like, I get it. You're gonna always have people more to the left because they feel like, um, especially if they've experienced it. So again, I don't minimize anybody's experience, but if you've experienced, you're like, my truth is my truth. But it may just be your word against him. How can he defend himself? If you say this happened and he can prove, if you would have said this 20 years, even 18 years ago, he can say, I was at the Grammys at that time. Here's the hotel room that I was at. That's a way for him to defend himself that did not happen. But how can he do that now? That's my point. It is very difficult as more time passes. As more time passes, okay, you getting blocked. As more time passes or whatever, that's just what it is. So, um, you said, I think people, let me see, let me go up. You can have witnesses, but when you have a witness on the stand, you do have to test credit. You can test credibility. So, for instance, when you do what I do and you go back and you talk to witnesses, oftentimes when they tell you renditions of what happened, it varies from what they said 20 years ago. That's just a fact. When you tell certain stories, it's not going to always be the same of what was 20 years ago. So, that's that. April said, well, Clarence Thomas would give him a vote not because he is Diddy. It would be because he has prior knowledge of harassment of women. Elite Leo said, I agree, and it should be a lesson for others to come forward sooner. I get what you're saying on that end, but we also have to, we know that it may not be easy for someone to come forward. But the issue is if you come from a civil litigation standpoint, right? Because if you want to stop somebody, the best thing to do is to go to the police and then get them off the street, right? But from a civil litigation standpoint, the purpose of having a statute of limitation is because claims get stale and you're not able to get the evidence that you would need to defend yourself. Or even on the plaintiff side, evidence get lost. She may not have, everybody ain't Monica Lewinsky, if you know what I'm saying. They don't keep evidence. like that, over years or whatnot. So I can see that being an argument. And I figured they would end up challenging the constitutionality. So Andrew said, no one scratch that. Two justice who would agree with Diddy. Right. So that is not true. So one of the reasons why a lot of these extended statutes even happened was because of what was happening in the Catholic Church. People were coming forward. They were the altar boy in the 70s. They had this experience and they would try to get some type of civil, action against the Vatican, the location where it happened, against the priest. Because what happened back then was they would find out priests was doing stuff and they would just shuffle them around to different, take them to different parishes. So they would be doing it again. They would just move them around. It wasn't like the Vatican didn't know. So they were trying to hold them responsible for it. But the statute, if you look at a lot of those cases, they were getting dismissed. So the legislature in many states were trying to make or create legislative work law so that they can have people come forward so that they can still sue them. So a lot of this stuff was actually precipitated from the Catholicism. So now when it comes to criminal aspect, they have longer statutes of limitation. So perhaps the argument can be, as long as they can investigate you criminally, they should be able to investigate you civilly. Maybe that's one. But it has to be a cap somewhere, because how are you going to even litigate this is what their argument is. Not saying yay or nay. I'm just saying I can see both sides, and that's all we do over here. ABC said in Diddy's case, it's obvious he's evil due to everyone else confirming it, but in most other cases, decades later, it's very hard to prove. Well, I don't know Diddy, but that's alleged. So that's what people are saying about Diddy. Tamika said it's not fair because he is rich. They would have taken her case years ago. That's true. I would have to agree with that. When you know that there are pockets, you have lawyers that would have been more prone to take the case. Shelby said, I'm not sure it's fair because defending oneself is difficult under the best of circumstances. Having to do it decades later is nearly impossible. Now, I agree with that from experience. When you have, like, for instance, in the criminal context, if when the person is originally charged, I'm entitled to discovery. I have subpoena power. I can go test evidence, look at evidence, and all of that. From this post conviction, which is prior, after conviction stage, you don't have none of that. You don't have subpoena power while you're trying to research and figure out and find people. At most, you can get a PI to try to help you locate people and all of that. You don't have the ability, at least where I am, to really look at the evidence. That's up to the judge's discretion. And do they really want to reopen cases because they're already backed up? We are in Detroit. You know what I'm saying? So I agree with that from experience. It's very difficult post conviction. Shedrian, thank you so much for becoming a member. And hopefully I said your name correctly. You're not late. Thank you so much for coming over here. Some people never come forward. That's true. VIP lady, that is true. So I think that their defense is just something I would have anticipated as being a defense. That's all. Daniel said, I hope this lady gets some justice and some peace. Yes. Patricia says some of this stuff ain't sounding right. We're gonna see. Oh, I knew somebody was gonna teach Teterboro. Is that correct? Teterboro. Thank you so much. So people were wondering, is Diddy just going to do what he did when it came to the Cassie situation and just pay him off? Does not look like that. I remember when Cassie sued, she also sued the corporations. He didn't even get served the complaint. I mean, there was not I think he settled it before the court even issued, because you can't serve a complaint until they issue a summons. I don't even think the court issued a summons before, and he had already settled it. But with this one, he did not. He answered it, and the first response for the corporations were, this needs to be dismissed. We ain't got nothing to do with it. Even if it is true what Diddy did, don't be blaming the corporations. And for Diddy, he said he didn't do it, and he's also challenging the constitutionality of the statute. So maybe she does have more evidence. Maybe she just scratched the surface. I think her being generic in the complaint will work against the individual defendants, but it may be a little bit different for the corporation, unless they argue discovery is in its infancy, because it probably didn't even start yet. They don't have, because you have a conference, and usually you meet and confer on how long you want discovery, and in federal court you have it longer than others. And discovery is, we're exchanging evidence, we're doing depositions, all of that. And so maybe their argument is, allow us to have discovery so that we can find people. Because I believe this young lady, she had a friend with her. Maybe the friend is willing to come and say what happened, and she can validate and verify they were there. Harvey Pierre was there, because I don't think the friend went with her to New York. So she can at least validate from being in Detroit in the lounge. No. Tracy said, who keeps texting 20 years ago? I know Verizon doesn't. They don't even keep text. Some carriers don't even keep text past a year. That's what I was saying about when we were talking about the Ernest Williams case. It was the same concept, that I was saying that was going to be an issue, because he's been in jail for 2 years almost. So if your defense is based on text messages or phone records, you need to preserve that, because they don't keep them forever. Now, hopefully the prosecution off rip subpoenaed them. Now, if the prosecution, I'm talking about the Ernesto case, obviously in this case, it's a wrap. And back then we had like beepers. Like, we didn't really have cell phones. I don't remember getting a cell phone like that till like college, maybe. Like, so back then, what she's talking about, it sounds like we had more of pagers, but I don't know. I guess I'm aging myself. Gigi said, if that defense is so credible, why did Bill Cosby did not use it? I Bill Cosby did not have, it's not, if this defense has never been used before, then that just means that Bill Cosby's attorneys chose not to use it. I mean, everybody doesn't use the same defenses. I would have challenged the constitutionality of it, because I know how hard it is. Now, will it work is the question. And if the judge denies it, how far is Diddy willing to go? Will the United States Constitution, United States Constitution, United States Supreme Court, will they hear a case like this? Because they can deny cert. They don't have to listen to nothing you have to say. But will this be something that they say they feel it's unconstitutional, that states can go up in their legislature and say, we're going to open a free for all, where if this happened to you, then you got a whole year where everybody could just file lawsuits. Is that against the Constitution, against your due process rights? That may be a constitutional issue that the Supreme Court wants to consider, but it's up to them. Kelly said, I 1,000% agree with you, Pam. How can a person defend themselves from allegations 20 plus years ago? It's ridiculous. Anita said, even though I could never stand his sneaky looking, he has the right to have a fair chance, like all of us, due process. I know, Anita, sometimes it's hard, but that's what I'm here for. We got to look at both sides. The claims against the Catholic priests are not barred by statute of limitation and case law against statute. I'm not sure what that means, but that is not true. There are plenty of cases that were dismissed from the Catholic situations. Google it. Go to New York. New York was one of the ones that I found a lot of cases. Michigan, I know, has some. There are statutes of limitations, and they do not allow you to file lawsuits. And because you're saying indefinitely or in perpetuity, they could just bring claims. That's not true. Now, you could find creative ways to hold the entities liable or something like that, but the individuals, there's a statute of limitation of assault. That is true. You say every case is slightly different, so that is true. You guys all have great points. Forever, Tania said, I am in favor of fairness and justice, but not for Diddy. So I really hope she can back up her claims if she's truthful. At least you're honest, Forever, Tania. At least you're honest. But he said, it's if true, sometimes when one been through trauma, sometimes they can remember after so many years, just like the wrongfully convicted. However, P. Diddy, etc., might not remember because they party too much, allegedly. That's a good point. Maybe they don't. Maybe he has so many girls that he don't remember one from the other, right? So, so when it comes to children, it's different, right? So when it comes to minors, it is different. So it's when I'm not trying to get that deep, but they have what's called the discovery rule. They have certain things when you are minors, you do get some leeway when some things happens when you are a minor of a certain age. So there are exceptions to statutes of limitation. If you were incompetent, if you were of minority, if you were, there are different, depending on where you are and what your cause of action is, there are exceptions to statutes of limitation. That is true. Did Cosby confess before? So the Bill Cosby case was very, very difficult because, of course, the first criminal case, I think it was a hung jury. One of the reasons why is because Cosby had done a deposition. In that deposition, which we all kind of seen, he admitted to putting Quaaludes in drinks. And he said that's what they did back in the day. So he admitted to slipping Quaaludes and all of that. But that case settled. As part of that settlement, that deposition was under seal, meaning that wasn't supposed to be open. Well, the first time he went, the judge left it under seal. So it was not presented to the jury. The second time he allowed, I think it was like three, and the judge wouldn't allow many victims to testify or something like that. I didn't follow it that closely, so y'all correct me. But I know that the deposition transcript and all the stuff he was saying that was kind of jacked up and things he was admitting to, that was allowed to go in front of the jury. I knew that would be a problem when it happened. And so of course he appealed it, got overturned, and that's why he was at home. So that's kind of what happened with him. He has a couple of, I think he had a new essay case that was filed around the same time that all these cases with Diddy and stuff. If the victims had solid proof, such as video and DNA, would matter as to how you can defend yourself because the victim has proof, but not for circumstantial evidence. How are you going to get DNA from 20 years ago? The only way you would get DNA is perhaps if like say for instance she went to the hospital and they did a RA kit or something, and sometimes they preserve them from the criminal aspect. You can retest DNA from back in the day, but I don't know how she would have DNA that would be preserved 20 years later. But hey, like I said, Monica Lewinsky did it, so I guess. Oh my. Unfortunately, Hugh Hefner died and Don Cornelius, or else they might have been in jail with man, Tarnika Wilcher. That's a word right there. Cause I saw that they have a whole series for um the Playboy Mansion. That series is crazy. I couldn't believe Hugh Hefner never got like nothing. And then part of that was Don Cornelius was at the Playboy Mansion too. Well, all of them were there. But yeah, Hugh Hefner, the stuff they were saying about him, I'm like, and he just none of this stuff, me too, none of this stuff even mattered until he died. And he lived like a full life. He didn't die young, any of that. He lived a full life and he lived the best life, I guess. He lived his best life. I know a lot of women that have been traumatized and victimized because of it. Sherry said that's why you email yourself and text screenshots, delete the name and just leave the number showing. Never know who's gonna act up. Listen, you hear Sherry? She giving you guys a heads up how to protect yourself just in case you gotta defend yourself. So, is there ever a time where discovery doesn't have to be given to the defense? So you can object to some discovery, but you have to have a reason. Discovery is what we call broad. So it's any information that could reasonably lead to admissible information. So it can be inadmissible, but if I feel like you giving me Sue's phone number might lead me to someone else, that Sue will lead me to someone else who knows someone else, then that's kind of how discovery is. So it's very, very broad. However, if I'm going and I'm not putting my mental health on display and saying that you mess with me, like whatever you've done to me has affected me mentally, and I go see a psychiatrist every week, then I'm going to object and say it's not relevant and you don't need it. Or if I'm in an auto accident and you say, I want your medical records from birth. You don't need when my mama pushed me out. That's too broad, like that's too much. So yes, there are limitations and you can object to it. And then the judge, see, in federal court, judges want you to sit and meet and confer and try to hash out any issues that you may have with discovery. And then if sometimes you agree to limit it, sometimes you do protective orders, which means that I'm going to give you this information, but you cannot let this get into the public. That means if you file a motion of any kind, do not attach this information I gave you so it doesn't get to the public because it becomes public record once it hit the system. So you can do it that way. And then after litigation, you tell them you have to destroy it or you can't give it to anybody else. You can do it in a protective order way, or you can try to fight it and say, no, judge, this is information that I need and I'm going to need them to give it to me. So, yes, there is a lot of litigation that occurs or a lot of motions that occur in litigation because people don't want to give discovery. People think you're asking for too much. People think it ain't none of your it ain't none of your business what you're asking for. It's not relevant and you fight. You always are fighting because the less, of course, the less information they have, you think it might benefit you. So then you have motion hearings. So when you hear like motion to compel discovery, that's the reason why. You get some people that evade and they don't want to sit down for depositions. So you got to do motions to the court for that. Like this person has been served, they have been noticed, they have been notified, and they refuse to show up. So you go to the depositions and nobody's there but you and the court reporter and the other attorney. And then you have to put on the record, listen, they were served 2, 3 times. We have a process server, all of that, and you put it on the record, and then you use that transcript to compel them to come. So, yes, the long way route from what your question is, there are ways to try to stop discovery, and it happens a lot during litigation. Yeah, that's pretty much what yeah, Maggie. That's pretty much what she's alleging. And so that's what the attorneys were using in their rendition of the facts, their version of the, it wasn't their version of the facts. I guess they regurgitated the facts, simplified from the complaint, and they were pointing out a lot of missing pieces. That's why they were saying an unidentified plane to an unidentified airport. You're going to bathroom with this guy. He does this, but you still decide to go on a plane. So that's pretty much what they were saying as well. Yeah. Wow. A lot of people did that back then. It was definitely a different time. Shelby said, I think Cosby wanted to go to trial. Phil, he and his team were confident that he would win. I don't know, Mike D, why you can't rewind. Miss Audie said, I empathize for victims, but there needs to be a time limit with the exception of children. Yep, there are exceptions for minors. Miss Audie, thank you so much for the super chat. I appreciate that. 5 EU Fox said, I am sick of Diddy. Okay. Wow. So Kwee says 20 years ago, the police would have thrown it out without a look because of how big he was. It could be. You may be right. You guys have some very valid points. So my phone just died. So if you were trying to text me, I didn't get it. Yeah, Val, you didn't hear about Don Cornelius? Mm-hmm. Yes, ma'am. Y'all like, share, and subscribe. We about to get up out of here. Thank you so much. Chi said, thank you. You are so thorough. I appreciate that. Where was the Playboy series? Was it on VH1? I don't know what app is on now, but I think it originated it definitely originated like on a cable network. Yeah, that's what they're saying. We're going to see how they respond to it. She's going to respond to the motion to dismiss. And so that's that. Shamira Sparling said it's difficult on both sides. The burden is lower in civil cases. That is true. You have beyond a reasonable doubt for criminal, which is the highest level. However, the burden lays with the plaintiff. That is true. Hence, that time seems to potentially prejudice both parties. Yes, I agree with both. I agree with all of that statement. That is true. It could prejudice. Sorry, that's why I need to get off here because I'm tired. Both parties. It definitely could. It's gonna be on credibility, and I think it's easier to cross-examine someone and make them look like they don't recall because it's so long ago. So if I'm a juror and I have someone sitting on the stand who doesn't remember half of the stuff, do I give a civil judgment for someone because what they're alleging? I mean, would I put this stigma that's going to be on Diddy after this, even though a lot of it's on him already? You know, it's a lot to balance. If you were a juror, could you be fair? Some people just don't like Diddy. And I'm sure if they do voir dire, which is to question the jurors before you impanel them, you will ask them, like, how many people have heard of Sean Combs? How many like rap? How many heard of Bad Boys? Do you like rap? Have you heard of what he's done? What it's been alleged? What are your feelings towards him? So they're going to have to do a whole lot of questioning, and it's harder. That's why getting a jury impanel, like you guys see probably in Georgia for the YSL trial, it takes longer because you have a high profile person who probably have heard about the case. When it's just Joe Smo from the East Side, it's easier to get a jury because they haven't heard of it. But this is a case where some people have opinions towards Diddy anyway, as some of you guys said. Some people felt like I just don't like him. So I hope she got all the evidence because I can't stand them. You get some people that's like that. So, okay. Max Lang said the Playboy doc was on A&E. Thank you, guys. Thank you. I appreciate that. All right, y'all. Well, we're going to get on out of here. Thank you guys so much for all the super chats and all of the new members and all of that good stuff. You know, I got to put Dre on before we leave because I want to make sure y'all like, share, and subscribe.
And another thing you notice, the first thing they say, make sure you guys hit that like and subscribe button. That's what it's all about. After they get them dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
Y'all heard him. Go ahead and hit that like and subscribe button. I'm going to holler at you guys. If I don't come on tomorrow, I'll be on Friday to try to discuss the Nesto bond hearing. See if he gets a bond. Will they give him bond? Will they drop the charges? What is going to happen? We don't know, but we'll see on Friday. Thank you guys so much for support. Make sure you hit the like button on your way out. Gotta go.
Bye.